on to the next subsection, competence, legal malpractice, and other civil liability. So here, this subsection of the rules makes up 6 to 12% of your total MPRE examination. I personally like this subsection of the rules. It's rather short and sweet. There are not that many rules found here under this subsection, and yet it makes up to 6 to 12% of your total exam. So I guess that was a long way of me saying I would be familiar with this subsection of the rules and then basically hope that it makes up to 12% of your total exam because there's not that many rules found here under this subsection. So the first rule that I would like to discuss here is all about competence. So the rule specifically says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for that representation. So a few things to keep in mind here that we have to discuss under this competency rule. What happens in emergency circumstances or emergency situations? The rules state that in an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation or association with another lawyer would be impracticable. Even so, assistance should be limited to what is reasonably necessary in the circumstances. So what this is saying is, though you might not have the competence to handle certain things, if the circumstances require it, say emergency circumstances, then you can move forward and do what you need to do. However, you should be sure that you do as little as possible to get past that roadblock and then pass that case off or the matter off to someone who is competent to handle it. The rule also talks about, how we can establish and acquire competence. The rules state that a lawyer can acquire competence through study or by associating with a lawyer of established competence in the field in question. So if there's an area of the law that you're seeking to practice or become more familiar with, you can simply work with another lawyer who has established their competence in that area of law. The rule also states that if a lawyer retains or contracts with other lawyers outside of their own firm to provide legal services to a client, the lawyer should obtain the client's informed consent first. And think back to confidentiality and some of these other rules that we've already covered. If you are going to step outside your law firm and get help from other lawyers, you need to first get your client's consent to do that. So keep that in mind. And then finally, the last piece of this rule is that the ABA model rules state that a lawyer should keep up with the changes in the law and must keep up with any continuing legal education programs required by their state. The next rule in this subsection that I would like to discuss is first to point out the difference between discipline and civil liability, because you may encounter some questions that assume that you understand this difference or could possibly be testing these differences. So a civil case would be brought in civil court. Rather than if you're being disciplined, that would be brought by some sort of committee in front of your state bar association or something like that. So that's the first big difference. If you're being sued for malpractice or civil liability, you'll find yourself in civil court. If you're being disciplined, you're going to be in front of the state bar or one of its committees. Another difference is if you are being sued for some sort of civil liability, you'd be sued by a plaintiff, probably a previous client of yours, who's claiming that you injured them in some way. This is important to keep in mind because this means if that plaintiff wins, any recovery would go to them or to benefit them. This is different than being disciplined because if you're being disciplined, the plaintiff or the client that you harmed isn't going to get anything at all. Instead, the disciplinary board or the committee that you're in front of, that the state bar basically puts together to decide these matters, will simply just decide what your conduct requires disciplinary-wise. For instance, are they going to fine you? Are they going to suspend you? Are they going to revoke your license? It just depends on your conduct and its severity. So again, keep those differences in mind. That way, sometimes these questions assume that you understand those differences, or they very well could be testing them. So let's talk about this civil liability. There are different ways in which a lawyer can have liability to a client. The first is in like a malpractice-like action or a negligence action. So to cover this, plaintiffs have to establish duty, breach, both types of causation and harm in order to successfully sue their attorney or their, previous attorney for malpractice. So to break this down, duty means that the lawyer owes a duty of care to act as a reasonably competent and diligent attorney would owe under similar circumstances. The duty here is owed to clients or potential clients if the attorney did not make it clear that the attorney was not going to move forward with the representation of that person. So that is duty. Breach is the idea that we've established that the attorney owed a duty of care to the client and then failed to fulfill it. In other words, an attorney will not be liable for mere errors in judgment, so long as the judgment was reasonable. That will not be considered a breach. Turning to causation, the plaintiff must prove that the injury would not have happened but for the defendant's negligence and that this injury was foreseeable. In other words, there are two different types of causation that a plaintiff would have to prove here to be successful in a malpractice case. Actual causation or but-for causation and proximate causation, or in other words, the harm must be foreseeable. This is oftentimes the hardest part of a client's case if they're trying to sue a lawyer for malpractice, because basically they have to show that but for the lawyer's negligence, the client's outcome would have been different. And that's obviously a very high burden to prove. You're essentially saying as the client that my case would have turned out different if my client wouldn't have messed up. And again, that would be hard to prove. And then finally, damages is that the plaintiff has to show that they've been damaged in some way to be successful in a negligence case. There are other ways, though, in which a lawyer can be liable to a client civilly, for instance, through intentional tort, like malicious prosecution, fraud, abusive process. Here, generally, plaintiff has to establish intent. Additionally, lawyers can be liable for breaches of contract and breaches of their fiduciary duties that they owe clients. There's also a limited set of circumstances in which a lawyer could possibly be liable to third parties or people that are not their clients. So here the rule says that an attorney also owes a duty of care to intended third-party beneficiaries. Thus, if the attorney negligently fails to properly draft a will or a contract making a specified person the beneficiary, that beneficiary can sue the lawyer even though they are not the lawyer's client. So again, that's kind of like the one instance in which a lawyer can have liability to someone that is not his or her own client. And then lastly, malpractice insurance and risk prevention issues. Pursuant to these ABA model rules of professional conduct, malpractice insurance or risk prevention insurance is not required under these rules. So again, I know some states require that, but for your MPRE purposes, you should know that the ABA model rules do not require that type of insurance. So I guess the last thing I'll say to wrap up this subsection is that remember the differences between civil liability and discipline. One thing I haven't mentioned yet is that it is possible that a lawyer could be disciplined for some course of conduct that they took in handling a client's case. But even though they were disciplined, that doesn't automatically mean the client will be successful in a civil claim against the lawyer. They are totally independent causes of action, so to speak, and they are independent of one another. So a lawyer could be disciplined for something. However, if they were sued for that civilly, they might win in that case, and the plaintiff might not be successful. So keep that in mind. And that wraps up that subsection.